If you're a typical financial professional, I think it's fair to say that most of your clients don't have their ducks in a row, legally speaking, when it comes to estate planning. According to a recent study, only half of the respondents had a will in place by age 50, despite most expressing knowledge that their lack of planning could leave a mess for their families to deal with. And in another study, only 55% of adults 55 years or older had a will in place. That's bad, but it's worse because 23% of the folks who did have a will thought that theirs was out of date. Fewer people, just 41% of respondents, had an advance directive for health care. And when we talk about the power of attorney, the stats are worse. Only 33% of respondents had one in place, and that can lead to significant cost and family frustrations down the road. Today, I want to share with you what I think you need to know about Georgia's revised Power of Attorney Act so that you can understand how the laws have changed significantly and you know the answers to some of the issues and questions that your clients are going to be dealing with. Then hopefully you can help your clients and their families avoid some costly errors as well as a lot of headaches. For those of you on the webinar I've not yet met, my name is Joel Beck, and I'm an attorney in Lawrenceville, Georgia with the Beck Law Firm, LLC. My practice focuses on two areas: estate planning and financial markets regulation and compliance for broker-dealers and investment advisors. Now, you can't have a program like this without a disclaimer, so very quickly, let me just remind you that this is an education session. It's not designed to be legal advice for your situation. So with that, understand, let's get to it. Today's program is aimed at financial professionals here in Georgia, those professionals who advise others on their financial affairs, such as financial advisors, insurance agents, and CPAs. And I'm speaking today to that audience specifically. We're going to discuss some important issues that you may very well be counseling your clients on in the context of your work for them. Now, during our time today, which will be a half hour or less, you're going to discover three things. First, how a power of attorney fits with a solid estate plan, what it's used for and what it's not used for, importantly. Second, why Georgia's laws on POAs needed updating and how they were significantly changed. And then three, how a carefully crafted POA under Georgia's new laws can help ensure your client's wishes are followed, his or her assets protected, and how your clients and their families can potentially save thousands of dollars in attorney's fees and other expenses, as well as significant frustration and headaches. So let's go ahead and dive in, and let's start and make sure that we're using really the same understanding here. So what is a power of attorney? It's simply a legal contractual arrangement recognized under state law that allows one person, who we call the principal, to designate someone else, who we call the agent, to act on his or her behalf and manage certain types of personal financial matters for the principal. Now, typically, a POA is used to make sure that if someone becomes incapacitated and can't manage their own affairs, can't manage their finances, then an agent can step in with proper legal authority to handle those tasks. And in some cases, it might be used as an act of convenience. For example, if the principal is out of town or busy, the agent could handle something on the principal's behalf. These days, the older we get, the more we face a real possibility of losing our legal capacity to manage our affairs. So a POA really can be necessary in older age, especially given the rates of dementia and other incapacities. So for this reason, we typically recommend that almost all of our estate planning clients include a POA as part of their estate planning overall. The cost of not doing so, which we'll discuss briefly later, can be high. So that's what a POA is, but let me highlight something quickly that a POA is not. It is not a way to distribute someone's assets to others at their death. The powers in a POA terminate immediately upon the principal's death. So an agent cannot act under a POA after the principal has died. That stands to reason because an agent can only do for the principal what the principal can do himself. If the principal has died, he can't act for himself any longer, so the agent can't do that either. Because of this, a POA is part of a solid estate plan, but it's generally prepared alongside an advance directive for healthcare as well as a last will and testament. Having a POA in place alone is not going to be an effective estate plan. Again, it's part of the overall plan, but it's not complete by itself. Georgia's POA laws were overhauled in 2017 in July and had some minor adjustments a year ago. And let me speak briefly about why that was needed. POAs had been around quite a long time. Historically, they were viewed as a contractual arrangement between the principal and the agent, granting certain powers to the agent. For example, the agent might be granted the power to manage the principal's bank accounts or investment account and to deal with insurance products, government benefits, retirement account plans, and more. A person was not required to use a standard form for the POA in Georgia or to grant or reject a standard list of powers and authority for the agent in the document. Well, because banks and other financial institutions were not a party to these POA contracts, they did not have to accept them and allow the agent to act on behalf of the principal. Some did, though. Others would do it provided the principal signed a POA form that was approved by the financial institution, but some others still refused to accept the POA at all. Well, as you might imagine, this can lead to problems. Take, for example, a case where a financial institution would accept the POA arrangement so long as the principal signed a form prepared by the financial institution. If the principal had the capacity to sign, was in town to do it as well, well, that was okay. But in cases where the principal no longer had the mental and legal capacity to execute the document, there was a real problem. And these problems weren't just limited to Georgia, but really had existed across the country. And so the Uniform Law Commission, which develops model laws for states to consider adopting, prepared what's called the Uniform Power of Attorney Act. As of today, 26 states, including Georgia, have adopted some version of the Uniform POA Act. They modified it with their own changes, and then it became effective under their state law. You can see on the map on the slide here which states have adopted it. In that gray, 4 other states or bodies, including District of Columbia, have introduced legislation as well. Georgia's version became effective July 1, 2017, with some additional revisions effective July 1, 2018 as well. Now, these new laws in the Georgia Power of Attorney Act, which if you want to look it up, it's the Official Code of Georgia annotated Title 10, Chapter 6B, Section 1 at SEC. It has been significantly changed, the landscape for POAs in Georgia. If the written POA meets certain requirements, then it will be treated under these new laws. So to receive the benefits and protection of the new laws, the POA must be signed on or after July 1, 2017, and it must be on the statutory form or use language substantially similar to the statutory form that's found in OCGA 10-6B-70. So what this means is that people who signed a power of attorney, whether many years ago, decades or a few years ago, or even just prior to July 1, 2017, well, they're stuck with the older Georgia laws governing those POAs. People who sign a POA today that does not meet the statutory requirements will have that POA governed by the old laws as well, likely to their detriment. In my view, the major changes in the law make it almost a necessity for everyone to update their POA to take advantage of the new laws. So what are the benefits? First, and most importantly, the POA provides a mechanism to seek to force a third party to accept the POA. This means that banks and other financial institutions, including brokerage firms, cannot simply refuse to accept a POA because it's not on their own form. Instead, they have 7 days from being presented the POA to either accept it, ask for a certification of it, or an attorney opinion that it's valid. They may not, under the law, require a different form. If this third party does not accept the POA, they may be ordered by a court to do so, and they can be held liable for the attorney's fees and cost of litigation incurred in obtaining that court order and enforcing the validity of the POA. Under the older law, there was zero ability of a principal or an agent to legally force the third party to accept the POA. So this is a very significant change. Having said that, there are a few situations where a third party does not have to accept the POA. And those include situations such as if the conduct being sought to be carried out is illegal, or if the third party would not be obligated to do business with the principal in that situation, or where the third party has actual knowledge that the principal has revoked the agent's authority. This ability to seek to enforce the acceptance of the POA is quite significant, and as I said, it's likely reason enough alone to update a POA to take advantage of the new laws. But there is a second major change, and that's the ability in the statutory form to designate a conservator if conservatorship proceedings are commenced on the principal's behalf. And as required in the new act, the court will make its appointment in accordance with the principal's nomination for a conservator unless there's good cause shown to do otherwise. So what does all this mean? Let's look at how this might play out, how the POA might be used in the lives of some fictional people. Let's take Alice, for example. Alice is 79 years old and now has dementia. It has gotten to the point where she can't manage her own affairs. She can't pay her bills, maintain her home, really take care of herself. She just doesn't have that capacity anymore. Then we have Fred, and Fred is Alice's nephew. Fred is concerned because Alice can't pay her bills and look after her house and everything else, that somebody needs to do something. So Fred files in the probate court to have a conservator appointed for Alice. And if a conservator is appointed, that person will, under court direction and with report back to the court, will be in charge of Alice's personal finances and affairs. So Fred volunteers for this task, asking the court to appoint him to that role. Now, this could be a very altruistic action, with Fred really caring about what's best for Alice and wanting to make sure she's looked after. Or it could easily be a situation where Fred has some type of ulterior motives and wants to get control of Alice's assets for some reason, maybe to enrich himself or his family in some way. If Alice has a POA in place under the new laws after July 1, 2017, an agent of her choosing would be able to step in and manage her affairs. And I'm sure she would be comforted that the person that she picked and trusted for this role was in that role doing the job and not someone that she didn't choose. Now, importantly, having the POA might eliminate the need to seek to have a conservator appointed, because somebody is there with proper legal authority to be able to step in and act as Alice's agent. But even if Alice has this POA in effect, Fred could file to start conservatorship proceedings and seek to have himself or someone else appointed in that role, maybe because he wants the power and control over Alice because he's not nominated as her agent, or in a case where she doesn't have the POA. Well, if she had the POA, then under the new laws, if Fred filed a conservatorship proceeding, the court would look to Alice's POA to see who she nominated to be her conservator. And if the probate judge determines that a conservator appointment is necessary, Alice's nominee will be appointed by the court to fill that role unless there is good cause shown as to why Alice's nominee should not serve. This way, Alice will most likely still be in control with respect to who is handling her personal affairs. So those are two of the biggest changes to the POA laws from the old act to the new, and they are quite meaningful. Well, let's talk about what an agent can actually do for the principal and what they can manage. In the statutory form, there are enumerated powers that the principal can grant to the agent. And if those powers are not selected, then by default, the agent doesn't have them. The powers come in two types: general authority powers and specific authority powers. You see the general authority powers here on the screen, and this includes powers to manage most every type of event or situation or asset that most principals would want to grant their agent to make sure that the basics can be taken care of. And most of the time, we're going to recommend that the principal grant each of these powers to the agent to maximize the benefit of the POA in handling everyday issues. But there are other specific authority powers that can be granted, but they are much more dangerous. For example, if you look at this list here on the slide, you'll see that one of the powers is the ability to create or fund a trust. So here, if this power is granted, the agent could establish a new trust with the principal's assets and then designate who the beneficiaries of the trust are and how the trust will be operated. And this could conceivably be done without the trustee's knowledge without the principal's knowledge or direction. Another power here is to create or change right of survivorship. Here, an agent can make certain assets be held as joint tenants with right of survivorship between the principal and someone else, perhaps contrary to the principal's plan or wishes. And then we also see one here to create or change a beneficiary designation. And this would apply to things like life insurance policies, retirement accounts, and other assets, and changing a beneficiary designation with the custodian of that asset. And if not done with the principal's wishes, consistent with those, that could thwart those wishes in his or her estate plan, perhaps. So looking at this list of powers, we see that these powers can indeed be dangerous, and so therefore they should only be used with great attention to detail. And if they are used, they may need to be limited in power by way of special instructions written in the POA form itself. Now, one thing did not change with the new act, and that is, like before, under the new laws, the principal can still terminate an agent's authority and then choose to make someone else his or her agent, as long as the principal has the ability at that time to execute such documents under the law. So that's what a POA does and what type of powers may be generally and specifically granted typically. Before we talk about how the updated POA can really prove to be very beneficial and possibly save thousands of dollars along with a lot of stress and headaches for the family, let me pause for just a moment and speak about what it's like to work with my firm in estate planning situations. I'm fortunate that we often receive referrals from financial professionals who've sent clients to us for help with their estate planning needs. Whenever we receive a referral like that, we're going to work diligently to ensure that the client receives the service that is more than worthy of the referral. If you have the occasion to refer clients with estate planning needs to a lawyer, I'd be honored if you would consider us. We'll strive to deliver top quality client service and address the client's needs in the most practical manner possible. And unless there's obvious evidence of client abuse, we're going to do what we can to reinforce the client's relationship with you as their trusted advisor, as well as work to make you look like the hero for introducing the client to us. If the client agrees, we can certainly keep you in the loop on the planning process, share information with you as appropriate, and if the client desires, have you sit in on the strategy session meeting as well, if you are so inclined. Know that estate planning is not something that we do here and there like some attorneys. Rather, it's a main focus area of my firm. We don't do everything in the world practice area wise. We've worked to limit our practice areas to specific places where we can stay current and focused, have a passion to serve, and can then deliver great work. Along those lines, I'm an attorney member of Wealth Council, which is one of the top national organizations for well-respected estate planning attorneys. And that gives me access to some incredible resources and tools that helps me deliver exceptional estate planning services to our clients. So if you have clients with estate planning needs here in Georgia, or if you've got questions about planning in Georgia, I invite you to contact me and let me know how I can be of help to you in your practice. Now, let's move on and let me hit a couple of ways that I think planning through a good POA can head off some big expenses and headaches. So earlier we talked about what a POA does, what the significant changes are under the newer act. Now, let's kind of talk practically speaking about how a well-written POA executed under the new act can really benefit a client, perhaps save them and their family thousands, and prevent a lot of headaches and stress and hassle. And the best way to do that, to highlight those issues, is to talk about two scenarios. First, a well-written POA will make sure that the right people are in position to step in and serve as agents. This eliminates the automatic need for a conservatorship proceeding, which is usually the route that you have to take when there's not a valid POA in place and the client has become incapacitated and needs someone to manage his or her affairs. That can cost thousands of dollars or more easily over time, and the client's affairs are going to continue to be subject to oversight of the court. By using a well-written POA, we're going to save those costs generally, and we're going to make sure that the client's wishes are still being followed as he or she set up and listed them in the POA, including with the right people that he or she trusted to serve in that role. Second, a good POA can also head off an unwanted conservatorship challenge, because by nominating the right people to serve as conservators if one is deemed necessary, the court is going to give deference to the principal's nominations absent good cause otherwise. And a court generally will not circumvent the principal's wishes unless absolutely necessary. So, if there is another family member that really wants to have control but hasn't been nominated as a conservator, knowing the absence of that nomination, that may head off that type of costly and litigious battle over whether a conservatorship should be appointed, because that other family member wouldn't be appointed as the conservator in any event because of the way it's written. There are two specific authority powers that should be considered and not immediately dismissed on that list of specific powers. And this can save some money, perhaps, as well as make sure that the client's estate plan is not thwarted and that the agent is going to be able to access and manage the principal's accounts. So you are likely aware as a financial professional that certain assets pass outside of the will by way of beneficiary designations on file with the asset custodian. Think of retirement accounts, IRAs, 401ks, what have you, life insurance as well, among other things. Well, I've found in my practice that clients don't always know if they've completed their beneficiary designations correctly, and they often don't update them when needed. And because of this, to make things as easy as possible, we stress the need in estate planning to focus on these beneficiary designations as part of the planning process, because you can make sure that these non-probate assets are distributed efficiently outside of the will through the proper beneficiary designations. But despite this, years down the road, perhaps the client may open a new account or a policy and not set up the beneficiaries properly, or not set them up at all. Or there could be a life change, such as a death in the family, that creates a need to update the beneficiary designation, but the client doesn't get around to get that done or doesn't know where to go and do that. Well, if this issue with the beneficiary designation is discovered by the agent and the client did not fix it himself, the only way that this can be addressed is if the client has granted his agent the specific authority to create or change a beneficiary designation in the POA itself. But as we talked about earlier, that's a pretty broad and perhaps a dangerous power to grant. So what we often have clients consider is to grant that power to their agent, but to limit it by stating specifically what the beneficiary designations can be. For example, in the special instructions, we can limit this power by stating that the agent can only create or change a beneficiary designation if the primary beneficiary is the spouse and the contingent beneficiary or beneficiaries are the client's children in equal shares per stirpes, and we name the children. Or we use other language as needed to make sure that the client's plan is captured and the appropriate authority granted to the agent. So by doing this, we make sure that the beneficiary designation can be modified, but only modified to be consistent with the client's wishes and consistent with his or her overall plan for asset distribution in their estate plan. One more specific authority power to discuss today, and that's one that allows the agent to exercise authority over the content of electronic communications sent or received by the principal. These days, as you know, more and more of our lives are lived out digitally and online. Bills and communications about accounts and assets may only come via email or other electronic notice through an app or whatnot. Paper is becoming a thing of the past, and that can make an agent's life very hard to know what's where and how to manage it. So the agent will often need the ability to be able to access the principal's email accounts and other electronic communications. And so by granting this authority to exercise authority over those communications, the agent will have a much easier time often, and this type of specific authority power may be very appropriate for many clients. Now, I want to be a resource for local financial professionals, and we've prepared a Georgia estate planning fact sheet designed just for you. This provides information on the estate tax rate, a list of family and life events that suggest a need to review a client's estate plan, as well as information about the three main planning documents used by estate planners in Georgia and some issues to spot that may identify that a client's documents are out of date due to changes in the law. We've got this printed and laminated so it's durable. You can pull it out of your file and refer to it as often as needed. If you've not received a copy of this in 2019, we'll be happy to get one to you. If you'll email me or call our office and request it, we'll need your name and a physical mailing address, and we'll get that out to you just as soon as we can while supplies last. If you've got questions about the Georgia Power of Attorney or other estate planning documents, I invite you to reach out to me. My contact information is here on the screen, and you can reach me via phone or email. If you want more information specifically about estate planning in Georgia for you or your clients, go to GwinnettWillsandTrust.com and request our free planning brochure, and we can send that to you automatically via email if you just fill out the request form on that site. Thanks for joining us today. I hope you found this information helpful and informative. Be sure to let me know how else we can be a resource for you, as well as share your ideas for future revenue topics. Well, that's our 30 minutes, and we're going to go ahead and call it a day. Thanks for joining us today.